Okay, good afternoon, everybody. Welcome to our Virginia Talent Network Employer webinar. My name is Anthony Reedy. I am the Executive Director of the Virginia Board of Workforce Development and part of the leadership team at Virginia Works. So I know we've got many guests joining us today and many still signing on. So we appreciate your interest and participation and part of this effort. Um, just a reminder that we are recording this session. We do want to make it available to you for reference or for other employers who are unable to join us today. So just wanted to again remind everyone that we are recording this and we'll send the recording out after the event. Also, a reminder that you will not be able to unmute your lines. So if you do have any questions later on, please feel free to drop those in the chat and we'll address them when we have that opportunity. So next slide, please. So, as hopefully you all have been able to join us for a few of these webinars. If not, this is your first one, then we welcome you. What we want to cover today, and this is really based on a lot of feedback from our engagement with you all, other businesses around the Commonwealth, as part of this series. And today we're going to frame around some compliance matters with new state laws and regulations that came into effect this summer in the Commonwealth of Virginia. As part of that effort, we've got some partners here with us from other state agencies, the Department of Labor and Industry to discuss worker safety, wages, and other labor laws. We've got our Virginia Employment Commission that can talk about changes in the unemployment insurance program, the new stand up of the paid family and medical leave program, and then employer self-service portal with VEC. And then our partners at the Department for Professional and Occupational Regulations discuss some licensing and regulatory changes of the regulations that they see here in Virginia. So next slide. As I had said, we've got our partners from Department of Labor and Industry, the Employment Commission, and DPOR here with us today. And this series, again, is brought to you as a joint partnership with Virginia Works, the Virginia Economic Development Partnership, and the Virginia Chamber of Commerce Foundation. This is our opportunity to share resources, information that could be beneficial to your business operations. Um, okay, sorry, just double checking. Hopefully you guys can hear me okay. I think we may have a couple of individuals that have some audio issues there. So hopefully I'm coming in loud and clear to everyone else. Thank you, see the thumbs up. Appreciate that feedback. So yeah, today we want to focus on those new laws and regulations in joint partnership with our many partners in the broader workforce development ecosystem. So next slide, please. Okay, and as a reminder that this is a recurring series, these lunch webinars, we host them on a regular basis between 12 and 1:30 in the afternoon. So hopefully you can enjoy some lunch while you listen and learn from what we're bringing to the table here, and an opportunity to engage with workforce innovators, peers, and program leaders to hopefully share resources and find solutions to some of your workforce and talent development challenges. And obviously, we want this to be a place where you can provide feedback to us. What information are you looking for? What resources do you need that could be beneficial? Because oftentimes you find out that these resources are available within state and federal government programs, but sometimes navigating the complexity of the system can be a challenge. So, that's our goal as part of this series, is to help breaks down some of the silos and pull back the curtain a little bit to show how we can people can access various resources and services. So next slide, please. And as part of that, I'd like to highlight the Talent Solutions Guide. This has been something that we've discussed on this series before. It's an online resource produced in partnership with a variety of other state agencies and partners who have a whole list of resources and programs that can benefit employers and workers. And it's we've there's been a couple iterations of this resource document, if you will, over the years, but we refreshed it last year with really trying to break it down within the life cycle or chapters of talent recruitment, from planning your initial stages, understanding what your workforce needs and kind of the workforce ecosystem, developing resources that can help with early career talent, including work-based learning opportunities, the process of hiring, how to tap into different talent pools. Are there incentives, tax credits, grants that can support that effort? How do you connect with the workforce system and the Virginia Workforce Connection and be able to source talent from the variety of resources? And then retention. Retention's often a part that doesn't get as much discussion, but we know it's important to the health and viability of many businesses. Is how do you continue to upskill and retain your talent, giving them opportunities to understand career pathway, providing on-the-job training or other services that can support them and having a fruitful career within your organization. So next slide, please. Okay, before we turn it over to our first speaker this morning, I did want to reiterate that the chat is live. So if you have questions throughout, and we'll take a little break in between presentations to discuss any questions or feedback from the audience. So again, if you have questions throughout, drop those in the chat. We'll pull them out at the appropriate time for the respective speakers today. So happy to engage with you all and answer any questions that you may have along the way. So next slide, please. And with that, I'm going to turn it over to our first guest speaker today. Micah Blankenship is a senior staff attorney for the Wage Protection Division at the Virginia Department of Labor and Industry. And he's here today to discuss worker safety, wages, and other labor laws coming into effect in Virginia this summer. So Micah, I'll turn it over to you.
Awesome. Well, I guess next slide there. First off, yeah, thanks, Anthony. Like you said, I'm the senior staff attorney for the Wage Protection Division. As a bit of background, the division enforces Virginia's laws that address pay. This specifically includes minimum wage, an employee's established rate of pay, prevailing wages, and overtime. Additionally, the division enforces Virginia's laws related to worker misclassification, the employment of children, anti-retaliation laws, right-to-work laws, non-competes, some anti-human trafficking laws, and other statutes related to employment in the Commonwealth. There were several labor and employment-related legislative bills filed during the 2026 General Assembly session. Today, I wanted to briefly discuss the ones that passed and were signed by the governor, some of which became effective July 1, 2026. Others have a more staggered effective date. Next slide. So first off, to start with, you have House Bill 1, Senate Bill 1. It passed and addresses the Virginia Minimum Wage Act. The law has no real immediate effect on the current 2026 minimum wage rate of $12.77 per hour, but it implements a defined increase over the next 2 years, ultimately to $15 per hour. Starting 2029, the Virginia minimum wage rate may increase each year due to inflation. It'll be indexed to inflation. This would be following the same methodology used over the past 2 years. The previous rate of $12.41 per hour, and now the current rate of $12.77 per hour. Also, within the Virginia Minimum Wage Act, there are a number of exemptions from coverage. House Bill 20/Senate Bill 121 passed, and it removes farm laborers and farm employees from these exemptions. So starting January 1, 2027, farm laborers and farm employees must receive at least the Virginia minimum wage rate for all work performed. Next slide. Also, House Bill 238 passed and became effective July 1, 2026. This legislation aligned the wage-related statutes in Virginia and establishes a uniform framework for enforcing minimum wage, overtime, worker misclassification, prevailing wage violations, and wage payment laws. Importantly, the statute now contains a clear definition of wages, which includes hourly wages, minimum wages, piece rate wages, day rates, salaries, overtime wages, legally required prevailing wages, commissions, tips, bonuses, and damages available due to the misclassification of an employee. DOLI has also been provided with enforcement tools such as the ability to issue subpoenas to employers and or make referrals to the Attorney General. The legislation also extends state law overtime protections to individuals who are employed by a home care agency or other third-party provider to provide direct support services. The statute provides a clear definition of direct support services, and that means personal care services that assist participants with instrumental activities of daily living, including grooming, toileting, bathing, eating, dressing, monitoring health status and physical condition, assisting with housekeeping activities, and other in-home long-term services and supports provided to an elderly person or person with a disability to meet such person's daily living needs and ensure that such person may be adequately function at home and have safe access to the community. Next slide, please. House Bill 675 passed and protects employees from immigration-related threats based on their made by their employer in furtherance of committing a wage-related violation. Aside from the remedies and associated penalties for any underlying wage violation, employers who coerce or threaten employees based on their immigration status shall be subject to a separate monetary penalty not to exceed $5,000 for the first violation, $9,000 for the second violation, and $12,000 for any subsequent violation. House Bill 636/Senate Bill 215 passed and establishes Virginia's new pay transparency and salary history ban. This took effect on July 1, 2026. The statute requires employers to include a wage, salary, or good faith pay range in job postings and hiring ads. The law also prohibits employers from asking job applicants during the application or interview process about the wages or salaries they earned at their current job or earned at past jobs. Employers cannot refuse to interview, hire, employ, or promote someone or retaliate against them because they decline to provide salary history or asked about a job's pay range. Applicants are still allowed to share their salary history voluntarily, including when negotiating a higher wage or salary after receiving an initial job offer. The Office of the Attorney General is responsible for enforcing these provisions, but DOLI hopes to soon release a fact sheet outlining this information and the general requirements. Next slide, please. House Bill 569/Senate Bill 518 passed and establishes a framework for Virginia setting state-specific prevailing wage rates applicable to public works construction. Essentially, DOLI will begin conducting construction worker wage surveys every 3 years to determine these wage rates. These rates effectively act as a minimum wage rate for certain construction jobs on public works projects. DOLI is currently in the process of promulgating regulations related to prevailing wages. More information on how to participate in that process will be provided at the end of this presentation. Also, House Bill 1207/Senate Bill 2 passed and created a paid family and medical leave insurance program. The VEC representative will discuss this more in a bit. But DOLI is tasked with investigating alleged violations, including retaliation, and may institute administrative proceedings to seek and/or collect remedies. Next slide, please. In 2020, Virginia passed legislation to prohibit covenants not to compete for low-wage employees. To determine whether an employee is considered a low-wage employee, employers must compare their earnings to the average weekly wage of the Commonwealth. For 2026, the prohibition applies to all employees who earn an average of less than $1,507.01 per week. In 2025, the legislation expanded the definition of a low-wage employee to include any employee who, regardless of average weekly earnings, is entitled to overtime compensation under the provisions of the Fair Labor Standards Act for any hours worked in excess of 40 hours in one work week. So in 2026, House Bill 627/Senate Bill 128 passed and expanded the non-compete prohibition to healthcare professionals. This term includes any person licensed, registered, or certified by the Board of Medicine, nursing, counseling, optometry, psychology, or social work. Also in 2026, Senate Bill 170 passed and provides that no covenant not to compete is enforceable without the employer providing severance benefits or other monetary payment to such employee, unless such employer discharges such employee for cause. The legislation also requires that the severance benefits or other monetary payment be disclosed upon execution of the covenant not to compete. I also wanted to just note that Senate Bill 100 passed and prohibits employers from retaliating against employees who miss work to respond as voluntary emergency responders during a declared emergency. Under this provision, affected employees may pursue remedies under the statute through a civil action in court. Next slide, please. House Bill 5/Senate Bill 199 passed and becomes effective July 1, 2027. Of note, this is separate from the paid family and medical leave insurance program, which the VEC will discuss shortly. This legislation requires employers to provide employees with sick leave. Sick leave must accrue at a rate of at least 1 hour per every 30 hours worked. However, an employer may provide a once-a-year dump or front load of all the leave that the employee is expected to accrue that year. Paid sick leave carries over year after year, with the caveat that an employee can't accrue or use more than 40 hours per year. That is, unless the employer allows it. Employees may use sick leave for their medical care or the medical care of a family member. Employees may also use sick leave to obtain services stemming from domestic violence, sexual assault, or stalking involving the employee or a family member. Paid sick leave is compensated at the employee's regular rate of pay and never less than the minimum wage rate. Employers are not required to pay out unused sick leave at the termination of employment. Next slide, please. As I initially stated, some of the new laws have a staggered effective date. Paid sick is one of those, and it is based on the size of the employer. So beginning July 1, 2027, employers of at least 50 employees must comply. Beginning January 1, 2028, employers of at least 25 employees must comply. And then beginning January 1, 2029, all employers must comply. Again, DOLI is currently in the process of promulgating regulations related to paid sick leave. Through these regulations, DOLI intends to better explain how employers can calculate their size for compliance purposes. The regulations will also address notice and record keeping requirements. The regulation shall be adopted by July 1, 2027. More information on how to participate in that process will be provided at the end of this presentation. Next slide. Yep. So House Bill 1092/Senate Bill 288 passed and directs the Virginia Safety and Health Codes Board to establish new workplace standards to protect people who work in extreme heat on the job. The forthcoming heat regulations must be issued by May 2028 and will protect workers working both outdoors and indoors, require employers to implement heat illness prevention protocols at certain thresholds, and establish clear science-based standards for protecting workers from heat stroke, kidney damage, or other heat-related health risks. Again, the process for promulgating these regulations, these standards has begun. Next slide, please. Like I said, um, if you have a pen or notepad handy and wish to participate in the agency's rulemaking process, please copy this email address. This is kristen.bernhardt@doli.virginia.gov. Please send any comments to Ms. Bernhardt. This will help ensure your feedback is documented and considered as a part of the rulemaking process. So if you can, take that down. But if you don't get that down today, you're always welcome to email the agency directly at laborlaw@doli.virginia.gov, and we can pass those along. Next slide, please.
Okay,
Q&A.
thank you, Micah. Covered a lot of territory there. So I did see we had a couple of questions pop up in the chat. So we'll prompt those, and then if you have additional questions, go ahead and drop them in before we move over to our next presenter. So Micah, the first question is around the wage and salary history. And the question is, are we as employers allowed to ask how much a person is looking to make in the next role or some variation of that? So not necessarily asking about, current or previous history, but, aspirational questions.
Aspirational question. I mean, that's a really good question. To be honest with you, I don't know if that's an area that we have necessarily considered at this point. I know the agency is in the process of drafting a fact sheet or a guidance document as it relates to this. I'm certainly gonna make sure I take down that question so that we can, whatever we put out, we can make sure that we address that. So I believe that's Mr. Giles. Mr. Giles, certainly be on the lookout for information coming from the agency as it relates to guidance documents for the pay transparency. But that's a really good question.
Okay, good. And again, using this forum as a way to bring some clarity to some of the questions. So the next couple are questions, and maybe I can bucket them into one question here real quick regarding the paid sick days. Well, I'll start with the first question, then the other two. Is paid sick days for all employees? Does this include temporary, seasonal, and/or part-time employees?
So yes, it does apply to all employees. However, I know that those specific kind of employee types or categories are being considered and will be addressed in the regulatory rulemaking process. So I don't have any specifics yet that I could relay, but that is certainly a consideration by the agency and will be addressed through the regulation.
Okay. Sounds good. And before the final question here, just want to note I did drop in Kristen Bernhardt's contact information in the chat. And again, we'll include that with the slide deck when we send the follow-up after the event today. So the final question before we transition over to the Virginia Employment Commission is regarding sick days again and how sick days relate to an employee's current paid time off, especially for employers who have an all-in-one paid time off policy.
Yeah, so the law states that you can front load paid sick leave. Now, the caveat to that, like if you are already providing some form of leave, it has to be as much and able to be used for the same purposes as paid sick leave. So if an employer is offering a leave package already, it must be able to be used by the employer or employee for the same purposes as what's outlined in the paid sick leave legislation, and be as much as that. And like I said, it can be front loaded. So, and we're also looking in the course of the regulatory rulemaking process as to what rules may differ or change for employees or employers who decide to front load versus employers who decide to track leave based on accrual. What differences in record keeping may apply for employers who choose one option versus another. But like I said, I don't have a ton of definitive information as it relates to paid sick leave at this time, since we are currently going through the rulemaking process. But just be aware that many of these questions will be addressed through regulation and subsequent guidance documents that the agency puts out.
Okay, sounds good. And maybe one other quick final one before we transition on. I know we've had a couple more pop in the chat, so we can look at responding to those individually or maybe some follow-up information. But regarding the employee count, is that based on the entire company or just the employees that are in Virginia?
Man, that is the great question. So that is a question that's came up several times recently, because we do have certain provisions of Virginia law where we look at number of employees in Virginia, and then we have others that maybe don't. That being said, that is something that is currently being discussed and considered in the rulemaking process, but it will be clear once those regulations are promulgated what that applies to, and it will provide a good way for employers, a clear way for employers to calculate employee size for applicability purposes.
Okay. Thank you, Mike. Again, a lot of great information, and as you've stressed today, that there's still a process to develop out the rules and regulations for a lot of this. So, an opportunity for the employers on this call today to get involved, to let the Department of Labor and Industry know your perspective on these, and you'll work through your respective industry or trade associations, other groups that you're a part of, chambers of commerce, things like that, to be a part of the process and making sure that the rules and regulations are a good fit for the Commonwealth. So with that, Nora, we can go ahead and move on to the next slide. And I'm happy to introduce Joanna Darkus, who's the Deputy Commissioner at the Virginia Employment Commission. And she's going to discuss with us today about some changes with unemployment insurance, go a little deeper into the paid and family medical leave program, which has already been referenced a couple times today, as well as the employer self-service portal. So, Joanna, the floor is yours.
Thank you, Anthony. Good afternoon. My name is Joanna Darkus, and I serve as a Deputy Commissioner here at the Virginia Employment Commission. I really appreciate the opportunity to be here today, as we at the VEC value this and other opportunities to hear from employers in the business community and build relationships that support a strong unemployment insurance and now paid family medical leave program for the Commonwealth. Next slide, please. On this slide, I'll provide a brief overview of the most recent legislative developments related to unemployment insurance, then spend a bit more time on the paid family and medical leave legislation, and then we'll follow up on after that with reviewing an important process update related to VEC's employer self-service system. So, to turn to the legislative updates, in 2026, VEC continues to implement unemployment-related legislation from past sessions, in addition to new measures that became law this year. This slide reflects a subset of those bills that I'll discuss briefly for your awareness. That past year legislation included the $52 weekly benefit increase bill from the 2025 legislative session. The effective date of that increase was January 1, 2026. When combined with the $48 benefit increase from the 2026 session, Virginia's UI benefit amounts have now increased by $100 across the board. That means the new minimum benefit amount is now $160, and the maximum benefit amount is $478. As the agency that administers the UI program, VEC is charged with ensuring that eligible unemployed workers have access to the income replacement benefits that will help them cover necessary expenses like rent, childcare, gas, groceries, and otherwise spending money at local businesses while they search for work and make contact with employers like you who may be hiring in their communities. Another bill from the 2026 session, SB 433, made Virginia the 34th state to allow some or all workers to receive UI benefits when they are affected by an employer lockout. 5 of Virginia's 6 immediate neighbors are included in that number. So DC, Kentucky, Maryland, Tennessee, and West Virginia already had such provisions. The law removed these lockouts from the broader labor dispute disqualification that remains in effect today. As we all know, lockouts are relatively uncommon nationwide as well as in Virginia, but VEC is prepared to receive these UI claims if they are submitted. We understand that increases in UI benefit amounts or coverage may raise concerns in the business community and beyond it about the impact on the UI trust fund and the potential for higher employer taxes. Historically, Virginia has maintained quite low UI taxes when compared to other states and the national average, and that still holds true in 2026. The final piece of UI legislation I'll address today simply created a mechanism for automatically protecting the already exempt UI funds on deposit in a bank account from being garnished from that account. Since UI benefits are designed to alleviate financial hardship for the temporarily unemployed, that exemption simply ensures that UI funds remain available just for that purpose. Now, for more than 70 years, VEC's mission has centered around administering the unemployment insurance program. In 2026, however, VEC was designated as one of the agencies principally responsible for standing up the new First in the South paid family medical leave program. And we'll do that in conjunction with the Department of Labor and Industry and other agencies like the State Corporation Commission who have their own critical roles to carry out. Because it's so new, I'll take some time to walk through a series of slides that explain the paid family medical leave program and the implementation timeline. Next slide, please. Much of what I will cover here reflects what we shared during the 9 virtual listening sessions we recently hosted on various PFML-related topics. One session focused on employers broadly, another on small businesses, and another on self-employed individuals, in addition to a host of other topics. We are actively sharing information about the program, including ways to share input, because our goal is to build the best possible program for all Virginians, one that's accessible and user-friendly and responsive to Virginians' needs, lifting up working families and supporting the Commonwealth's long-term economic stability. To that end, here's a brief overview. In short, Virginia's paid family medical leave program will provide up to 12 weeks of job-protected paid leave for Virginians to welcome a new child through birth, foster care placement, or adoption, to recover from a personal serious health condition, to care for a family member with a serious health condition, and for military family needs. The law also covers up to 4 weeks of paid leave related to domestic violence, sexual assault, or stalking. The benefits will be paid out from a trust fund into which the small payroll contributions from employers and workers will be deposited, with an option for self-employed individuals to pay into the fund too. Workers will be able to submit an application to the VEC to seek wage replacement for those qualifying reasons, and that empowers employers to offer their workers a benefit that has been out of reach for many, especially our partners in the small business community. And that also empowers Virginia workers to take leave without sacrificing financial stability or job security when they need it. The program will provide wage replacement of up to 80% of the worker's average weekly wages, up to a cap of the state's average weekly wage, which is currently $1,507.01. Next slide, please. Many of you may be familiar with the federal FMLA, or the Family and Medical Leave Act. Virginia's benefit is distinct from the FMLA in that we have wage replacement that puts the paid into our new paid family and medical leave program. Under the FMLA, employees are extended certain job protections and an ability to retain their health insurance coverage and other benefits while on leave, but FMLA leave is unpaid. That's a critical distinction of our program. To finance the wage replacement, initial contribution rate will be set using some actuarial analysis in the fall of 2027. This is the contribution that will be split between the employee and the employer, which generally speaking will be split 50-50, though employers may choose to cover a larger share of the employee's contribution. Employers with 10 or fewer employees are not required to pay the employer share of the contribution, but they will still be responsible for collecting and remitting the employee share. To respond to 2 questions from employers, next slide, please. We'd want to note that employers may offer private plans that meet or exceed the state program. That's a feature of the legislation. And the legislation explicitly states that employers may offer supplemental benefits above the baseline paid leave offered through the state program. We've also received questions about how to determine worker eligibility. The program will cover full-time and part-time Virginia workers who earned at least $3,000 total across 2 of the last 5 quarters. The paid leave benefits are an important feature of this program, and job protection covers workers who've been employed for at least 120 days by their current employer. To answer one other frequently asked question, the law states that any leave taken with wage replacement through the paid leave program that also qualifies as leave under the Federal Family and Medical Leave Act will run concurrently with leave taken under FMLA. Next slide, please. Here, I'll go over the timeline, including some key dates for the rollout of this program. By October 1st of 2027 and each October 1st thereafter, VEC will set the contribution rate for the following calendar year. By April 1st, 2028, payroll contributions will begin, and by December 1st, 2028, VEC will make sure that family and medical leave benefits become available to covered individuals. Next slide, please. Along the way, VEC will issue regulations governing the program. We expect to issue proposed regulations for public comment by the end of this year. Here's an overview of the regulatory process. First, this past June, we issued a notice of intended regulatory action with a 30-day public comment period that ran through July 15th. VEC has reviewed each comment received, and we're working to incorporate that feedback into the regulatory drafting process. Once the proposed regulations are published, there will be a 60-day public comment window. Input received at that time will inform the final regulations that we expect to complete in 2027. An easy way to stay in the loop about this process is to sign up for VEC's PFML mailing list. Next slide, please. If you go to VEC's PFML website, you'll find that a sign up for that mailing list so you can be notified when the proposed regulations are published and receive other key program updates. We are still developing this program and regulations, and we really value feedback as we do that work. So we hope that you will take advantage of this opportunity to stay engaged and help us understand what we need to do from your perspective to make the program work for your businesses, for you as a Virginian yourself, and for your workers, your workforce, and your families and their families alike. So while paid family and medical leave is a program that's still being built, and getting great stakeholder feedback is just an essential part of that process. Next slide, please. While we are building the paid family medical leave program, we're still focused on finding the best ways to serve you as the business community and workers who need access to unemployment insurance. And one of the upgrades that we recently made was to our employer self-service system. So the big change there is that for those of you who access VEC's services who previously accessed VEC services through the Virginia Department of Taxation website, that has now transitioned to VEC's own website. So the employer self-service portal is on our website. And along with that comes some security and anti-fraud and other measures that are going to help Virginia maintain the strongest UI program we can. So that access, if you use the ESS system, now requires ID me as the source of digital identity verification. And that's a key anti-fraud measure. And we want to make sure that you understand that while as of August 1, 2026, this is the way to access ESS now, it's important for you all to know that it's not your only option. There is still web upload. There are e-forms for employers with fewer than 25 employees. And we have heard feedback and recognize that ID.me may not be the preferred option for every employer. So we want to make sure that we continue to do the work that's responsive to that feedback and make sure that the other options you have available are accessible and meet the needs that you have for your business. We're actively exploring additional options, and we appreciate feedback that the employer community has shared with us as we continue to try to improve the experience that you have with this program and our agency. So we're listening to that input. We welcome more input, and we want to be in a position to respond to it. Next slide, please. While we're all going through this transition to the new ESS sign-on process, just want to make sure that you're aware of all of the resources that are available on our website to walk you through how to make sure that you're signed up. Here, we have a dedicated website where you can view job aids and videos that will walk you through the steps to set up your new account, get access to it using ID.me on VEC's website. Beyond that specific transition, there are other resources that are readily available for helping with sides reports, for helping with other employer-facing concerns that we want to be responsive to. We've heard from employers and TPAs about the need for these resources, so we have put them on our website, and we want to make sure that you know that they're there for you. And if there are other resources you need, we hope you'll reach out. There's also information about the best ways to contact us. We have a dedicated employer line for direct assistance. It's 866-354-5579, and you can learn that and other information by visiting our website and viewing the materials there. So overall, just want to make sure that you understand that when it comes to the employer self-service portal, we hear that we look forward to you engaging with that platform. When you use ESS, you can respond to separation reports, file tax and payroll reports, and view quarterly tax report and view wage reports there. And those of you who are familiar with SIDES, just want to make the distinction. SIDES doesn't do it all, but ESS is a good way to manage everything. And SIDES is just for the separation report. So you can engage with both, but it's not an either or. If you're only doing SIDES, that is not sufficient. So hope that you will log on to our website and ensure that you have what you need to continue to respond to the separation reports, but also submit your wage reports and quarterly information. Next slide, please. Welcome your questions, and we really value the input that we've received from you, and look forward to further engagement.
Thank you, Joanna. Again, a lot of great information to share out with the audience today. We do have a couple of questions in the chat going back to paid family and medical leave. First question regards if both a husband and wife, two spouses work at the same workplace, are both eligible for the 12 weeks of leave when a child is born.
So thanks for the question. The program, there are going to be questions that we can't answer because of regulatory development that's still in process. The program is still being built. But overall, what we can say from the legislation is that eligibility hinges on whether a person is a covered individual, and each worker is a separate person who can separately apply for the benefit. That's how the legislation is structured. And so as long as the individual has a qualifying reason, they are eligible to apply. And if they have time within their 12-week window available, then they should be approved for leave as long as they meet the program requirements.
Okay, thank you. And other question is the program the company can enter to, is this basically a voluntary program the company enters into, or something mandatory for every company?
The legislation creates a mandate for all Virginia, that covers all Virginia workers. So it's not optional, it is mandatory.
And there's the caveat that if an employer already has a program that meets or exceeds the benefits in code, then they just move forward with the current program that they have, correct?
The statute sets it up so that employers, there are two ways to comply with the program. One of them is to participate in the state-run program. Another is through private insurance products or offerings. And the legislation is structured so that any of those private options must be reviewed and approved by the agency. So there is a review process to ensure that those other offerings do in fact meet or exceed the state's requirements. And we will provide information about that as we proceed.
Okay. Okay. Two more questions. One more follow-up question on paid family and medical leave, and then one on ESS. For paid family and medical leave, if the employee is Virginia, but the employer is from another state, are there any rules around that?
Through the regulatory development process,
Mhm.
This is a topic that will be addressed. And so you're welcome to provide input about what we should consider and the difference that would make for Virginia.
Okay, sounds good. More to come on that one. And then on the ESS question, if we have sides and have responded to separation reports, how do we find that status? Is it through the ESS website?
That is a really good question, and I would need to phone a friend to make sure that that I'm giving you exactly the right information, because since different employers use different systems, I don't want to provide the wrong answer here. So happy to respond offline for that one.
Okay, sounds good. Well, and being cognizant of the time, we'll go ahead and move on to our next presenter. But if you have additional questions in the chat, feel free to drop those in there, and we can go in and respond to those individually, or maybe provide some additional resources at the conclusion of the event. So, Nora, if you'll go ahead and advance. Okay. Our next two presenters are from the Department of Professional and Occupational Regulations. We have Joe Howlett, who is the Regulatory Affairs Manager at DPOR, and Eric Bottle, who is Communications and Digital Manager for DPOR. So, gentlemen, I'll turn it over to you all for the presentation.
All right. Thank you, Anthony. I'll go ahead and get things kicked off, and then I'll hand it over to Joe to provide some additional information after I'm done here. First of all, we're very pleased to be able to speak with everyone today and share a little bit about some recent regulatory updates that may be of interest to you. Next slide. And go ahead to the next one. So just for anyone who is not too familiar, a brief intro about DPOR and what we do. So our primary mission is to protect the public, and we do that by holding professionals and businesses to consistent standards of competence and conduct. And through that, we help create a level playing field for everyone out there. We do that by issuing licenses. We investigate complaints, and we discipline anyone who's found to have violated a regulation. The structure through which this happens is we have 16 regulatory boards that set the standards and review these disciplinary cases. And we also have two boards where the agency director actually holds the ultimate regulatory authority. So those are two advisory boards. But altogether, these boards oversee more than 50 professions and occupations. That includes some of our larger license holder populations, like contractors and real estate professionals, and everything to cosmetologists and even professional wrestlers. Right now we have almost 328,000 license holders here in Virginia. That's as high as we've ever seen. And our boards operate in full view of the public, so all the meetings are advertised in advance. You can see all the meeting minutes and any regulatory updates on Virginia Town Hall website. And you can see that there on the slide, townhall.virginia.gov, if you want to keep track of individual board actions and those regulatory changes. Next slide. So, as you can imagine, with as many licensees as we've ever seen, some of those folks are coming from other states. We want to, of course, recognize their skills and experience and help them get licensed in Virginia without having to duplicate a lot of the training and education they've already received through licensure and the state they're coming from. So our way of doing that is a program we call the Universal License Recognition. It's been around now for 3 years. It became effective in July 2023. And it allows individuals with valid license or certification in another state in a similar scope of practice to qualify for a license from a DPOR regulatory board if they've been licensed for a specific period of time in that other state. And that we'll get into this a little bit later, but that experience requirement was 3 years, and it's now 1 year. And this program applies to most all of those professions and occupations I mentioned before. So the 50 plus, except for there are a few exceptions. There's a handful in terms of professional services that this would not apply to, and that's like architects, professional engineers, land surveyors, landscape architects, and geologists. But all the others, if they've met standards related to training, education, and experience, and passed the examination in the original state where they were issued the license, they qualify. They would also have to pay the licensing fee here in Virginia, be in good standing in the other state, of course, have no pending investigations or unresolved complaints in that other state, have no disqualifying prior discipline. So, nothing that would have been deemed harmful to the public. And then also have no disqualifying criminal record. So different states treat that last part differently. Virginia doesn't have what is called like a barrier crime that would outright prevent licensure. Boards review convictions according to the law, which says an individual can't be denied a license solely based on a criminal conviction unless that conviction is directly related to the profession or occupation for which they're seeking licensure. Sometimes people are coming from states where the profession is not licensed. So those who practice a profession or occupation in a state that does not require a license, they may have their experience recognized if they've been practicing for 3 years. That 3-year requirement holds for those folks with coming from states where they weren't required to have a license. And of course, they would have to pass the Virginia board's exam. Some boards may require jurisprudential examination. Essentially, that means testing on relevant state laws and regulations that all the other licensees in Virginia must pass. So, for example, in Virginia, the Virginia Real Estate Board would require this examination. Next slide. There have been a couple of key updates since this universal license recognition became effective. The first was in 2024, and that allowed those licenses in neighboring states. So you can see them listed there: DC, Maryland, North Carolina, Kentucky, Tennessee, and West Virginia. People coming from those states would not have to meet that experience requirement, but this applies to only occupations regulated by the boards you see there. So that's Real Estate Appraiser Board, the Real Estate Board, Board for Waste Management Facility Operators, and Board for Waterworks and Wastewater Works Operators, and on-site sewage system professionals. As I mentioned before, just this year, the statute was modified again to reduce that experience requirement from 3 years to 1 year. So that will probably open the door to other people to take part in this and get them licensed in Virginia. The program, like I said, has only been around for 3 years, but it's been pretty successful so far. As of last month, we've had over 2,000 credentials issued under the program. Most of these are going to tradesmen, so electricians, plumbers, HVAC, and those that work in real estate, so brokers and salespeople. But also cosmetologists is the third highest ranking profession in terms of making use of this program. And on that note, I'm going to turn it over to my colleague Joe, our regulatory affairs manager, and he's going to give some updates that are actually of particular interest to cosmetologists and contractors, our largest regulant pool. Joe?
All right, thank you, Eric. If you can, we can move on to the next slide, please. So one of the changes that took effect recently was a reduction in the minimum amount of training hours an individual would need to qualify to take the examination for a cosmetologist here in Virginia. So prior to September of 2024, an individual, if they wanted to qualify for the examination, they had to complete 1,500 hours of training in cosmetology. The Board for Barbers and Cosmetology cut that by a third, and so now it's only 1,000 hours of training that is required for someone to qualify for the license examinations. This started as a result of some legislative interest during the 2022 General Assembly session. The board formed a committee which took a real down in the weeds look at all of the training requirements that an individual would need under the regulation that was in effect then, and determine what things were essentially necessary for someone to become minimally competent to practice cosmetology without risking the public health or safety. And so ultimately the board's committee and the board determined that they could successfully reduce the number of required training hours without creating a risk to the public. So that has provided a benefit to individuals who are, want to become cosmetologists, gives them a cost savings as well as a time savings. They can get licensed sooner because they don't have to spend quite as much time taking the training in order to qualify for the examination. And sort of picking up off that success of the cosmetology training requirements reduction, the board has also recently reduced the training requirements for those who are seeking barbering license. So effective this past December, those seeking a barber license, they now only need to have 750 hours of training rather than the previous requirement of 1,100 hours of training. And then those who are seeking a master barber license would only need an additional 250 hours of training rather than the previous requirement of 400 hours. You can move on to the next slide, please. And the other significant regulatory change is in the realm of contractors. And so this past September of last year, the experience qualifications for Class C contractor licenses, that's the entry level of contractor licensure, those were reduced. And to provide a little bit of context to this, contractor licenses aren't issued to individuals, they're issued to business entities. But each contractor license has what I'll call human parts. One of those human parts is what's called a qualified individual, and that's an individual who is either a member of the company's responsible management or is a full-time employee of that company that meets a specified experience requirement in the scope of services that a contractor will perform. So for instance, if a contractor is going to be a building contractor, their qualified individual has to have experience in performing residential building construction and pass an examination. So prior to last September, that qualified individual had to have 2 years of experience to qualify for that type of license. That has been changed, and now they can qualify for that. That company can qualify for that license if their qualified individual has a minimum of 1 year of experience in that scope of services. And so for those that may not know, Virginia has 3 classes of contractor licensure. The lowest level of licensure is called the Class C license, and that those folks are limited to contracts or projects that are no more than $30,000. Class B contractors can take on, they're sort of the mid-tier license, they can take on more, and then a Class A contractor can take on projects of any value. And of course, as each class of license, as you go up each class of license, the experience requirement adds up. For Class A contractors, I believe the requirement is 5 years of experience. And then in addition, the Class A and Class B contractors have to meet certain financial responsibility requirements and have another individual who is part of that company pass an examination on business and state laws and regulations. So that's just kind of a brief overview of the some of the recent regulatory changes here at DPOR. We can move on to the next slide. And certainly welcome to entertain any questions that anyone might have.
Thank you, Joe and Eric. I appreciate the updated information about the great work that DPOR is doing. And it's always good to see, individuals coming from out of state moving into the Commonwealth to work and hopefully establish lives here. So appreciate that effort to make that process easier for people to get into the workforce. So with that, we will open it up. If you have any particular questions for the team at DPOR or going back to any of the other previous presentations, go ahead and drop those in the chat, and we'll just give everyone a couple minutes to do that. If you have any other pressing questions, as a reminder, we did record the event today, so we'll share it out with everyone with any other relevant information. And again, a great opportunity, as you can tell from today's presentations, to get involved in the rulemaking and regulatory process. So several opportunities for you as individual employers, as Virginians, to comment on that regulatory process to make sure that your perspectives are being heard. So with that, I don't see any other questions popping up in the chat. So Nora, we can move on. Okay. And again, just as a matter of wrap up, again, we want to thank our partners from the Department of Labor and Industry, the Virginia Employment Commission, and the Department of Professional and Occupational Regulations for joining us today and sharing about the important information that you need to know with your businesses to be in compliance with new state laws and regulations. Obviously, I appreciate the support of the Virginia Economic Development Partnership and the Virginia Chamber of Commerce Foundation for their effort in building out this webinar series and the information that we provide. And again, thank you all for taking time out of your busy days to join us here to learn more about what's going on at the Virginia, to learn more about things that will benefit your businesses. And as always, feel free to reach out to us. Our contact information is listed here as a way to get involved with the system, learn more about resources that's available, and also let us know what you need to be successful as businesses, and we can identify the resources across state, local, and of course the federal government to make sure that you have the information and resources you need to be successful. So with that, thank you all again so much for your time and attention today. Please feel free to reach out to us following the event, and if not, we'll see you at the next one in October. So thank you all very much.